Thank you. Again, good afternoon, everyone, and welcome. Thank you for joining us today for our webinar titled Covenant Enforcement for HOAs. My name is Michael Manrique, and I'm the Director of Marketing with Affinity Management Services. And as Jeff mentioned, I will be your host today. So we're excited to have you here for what will be a practical and timely discussion designed specifically for community association managers and HOA board
Hmm.
members. Um, since we're gonna wait for everyone to trickle in, we're gonna have an ongoing question. Number one, if you guys could answer in the chat, if you're a CAM or a board member, and what city are you joining us from today? If you could put that in the chat.
It's always fun to see who's coming from the furthest.
That's right.
Yeah.
Let's see who we got here. Oh, we got Sarasota, Bonita Springs, Vero Beach, Merritt Island. All right, we got some cams. Oh, whoa, here we go. It's coming in fast and hot. Excellent. Excellent. So it looks like we got a group from all over the state. This is absolutely wonderful. Oh, wow. This is great, guys.
Yeah. Someone in the Keys, someone on the West Coast. Yeah.
I saw California there too, Fred.
Yeah, California, Delray Beach. Excellent. All right. All right. Thank you guys for participating and sharing. What I'd like to do now is introduce again, we'll bring back Jeff Solomon. He's the business development and education director for KBR, and he's going to provide some housekeeping information to make sure you guys get your credentials and how this webinar is going to go.
Thank you, Michael, and thanks for inviting us. It's always a pleasure to collaborate with you guys. We appreciate you very much. Thank you. For those that have attended sessions with our firm before, just this will be repetitive for you, so I apologize if it is. But for those of you new to us, today's course, if you are a manager, a licensed manager in the state of Florida, or a board member of a homeowners association, you will get a CEU for today's class. You're more than welcome to hang out and remain on with, if you're a condominium or a cooperative board member, you're going to learn a lot as well. But in terms of credit, HOA board member and Florida Community Association manager. In addition, please remember that anything you hear today should not be considered as legal advice. This is for educational purposes only, so please don't go back to your board meeting tonight and say, Emily said this during the class, this is how it's got to be. That's not how this works, okay? So if you're not sure about something, please contact your association counsel, your manager, or anybody that can get you to your association counsel. Now, you've already been typing into the chat for with regards to where you might be located today. So keep in mind that I'm going to be disabling the chat in a moment, and the way you're going to be asking your questions will be in the Q&A module. That's a different module from the chat, not to be confused. Okay, so the Q&A module is where you're going to type your course-related, on-topic, general questions. Please don't get too specific. We don't have neither Michael nor Emily has your documents in front of us. So please keep your questions shorter and very general, not too specific. And we'll answer as many as we can, time permitting, at the end of the session. However, do not turn the chat off so that it disappears. Leave it there so you can still see it, because towards the end of the session, we're going to place a link for the required evaluation, which we use to cross-check with the attendance sheet. And should you ever get challenged that you were here, we have 2 layers of proof to help prove that you were here and get you your certificates. Lastly, your certificates will be emailed to you to the email addresses you used when you registered for today's session. That'll happen within 3 to 5 business days or so. So keep tabs on your spam and junk folders as well. That will come from seminars@kbrlegal.com, but I'll go over that again at the end. Don't want to waste any more time. I am going to kick it right back over to our host. Back to you, Michael.
Thank you, Jeff. All right, everyone. Joining us today as our featured speaker is Emily E. Gannon. Emily is highly experienced in community association law and works closely with boards and managers on covenant enforcement, compliance, and dispute resolution. She brings a very practical and real-world approach to helping associations enforce rules consistently while minimizing risk and conflict. Right now, I'd like to welcome Emily to the chat.
Thank you, Michael. Hi, guys. Nice to see everybody, sort of, kind of. There's a lot of you here. I think it's almost 300 already logged in. But as they said, we're here for covenant enforcement for community associations. So we are going to be talking about condos, co-ops a little bit, HOAs. It just, the confusing part is you only get the credits if you're a CAM or if you're on an HOA board. So we are covering everything, but credit-wise, CAMs, HOAs, you're going to get credits. Condos, there's no credit for today, but we are going to talk about you. You're not left out. So if you're here, I saw some comments, hey, I'm on a condo board, should I stay? I say yes, you're still going to learn things. But let's dive in. So let me pull up, and Jeff, just make sure this is going to work.
Sure.
We updated our system over the holidays and we've had some, you can see that, right?
Yeah, we're good.
Okay. All right. So that's our little intro page. As we said, today's just supposed to be educational for you guys. We're going to kind of do a covenant enforcement 101. So we're going to go over generally what that means, what, we're not covering every topic under the sun. We're not going to be talking about SIRS. We're not going to be talking about budgets. So if you do have questions, like Jeff said, please keep them sort of tailored to just what we're talking about and really the general topic of covenant enforcement. I'd love to help all of you, but you can't, type in a whole scenario of, hey, we have a 5-member board and Bob is a jerk because he's not doing the proper things. And here are all the things we have problems with him with. He doesn't clean up after his dog. He didn't get approval to paint his house. Love to hear all of those stories, but we can't kind of get into them today. So we will get into some hypotheticals that talk about those things, but not probably your specific set of situations here. So let's dive in. So I'm from K. Bender Rembaum. We are an association firm. That's all we do is association work. And that's everything. I mean, we do collections, we do contract reviews, we do document reviews, but covenant enforcement is a big part of what we do because obviously, as you guys know, it's a big part of what you have to deal with as board members and as associations. Now, there's my profile. You can read that later. Basically, all you need to know is I've been with the firm. This is going to be 14 years. Kind of crazy, right? But like I said, this is what we do all day, every day. And we'll dive in. All right. Covenant enforcement. What am I talking about? What does that mean? Those are fancy sounding words. What are we talking about here? Covenants, when we say covenants, we mean essentially it's another word for a promise. When you moved into your community, when you became part of the association, essentially you made promises to the community, and the community is really making promises to you through its declaration of either the declaration of condominium or your declaration of covenants, restrictions, easements, probably something like that. If you're in an HOA, that's probably what your declaration is called, some variation of those words. Covenant means promises, essentially, right? You're going to pay the association. The association is going to provide certain services for you. They're going to have security or a gate. They're going to make sure that the owners are following certain standards and criteria, ARC things. Maybe you're a 55 and over community. These are all sort of those promises that are incorporated in your declaration and that everybody is supposed to comply with. And that's really what we're talking about. So now the board is the entity that operates the association, right? That's the group that has the responsibility. I know no one likes to be the bad guy, but if you're on the board, you signed up for it, right? You have the duty to enforce these covenants, the covenants that are in the governing documents for your association. That includes what's in your declaration. That includes maybe some rules and regulations. Those are the covenants. That's part of your job being on the board, is enforcing these things. You have a fiduciary duty to your community. That's what you need to be doing. Now, if the board doesn't do that, if the association doesn't enforce its covenants, that raises a whole new potential for issues. And if they're not enforced timely and uniformly, we may run into an enforcement issue down the road. And that's why sometimes you see that, a declaration may say that you can't have X in the community, but when you drive through the community, you see lots of X. Maybe it's a, no truck community, but yet you see lots of trucks. And we'll get into that scenario down the road. But that's where if you don't enforce things properly to begin with, you may run into this problem and may not be able to enforce down the road. And we'll get into, again, like I said, all that stuff down at the end here. Covenants, like I said, some examples to think about: architectural standards, age restrictions when we talk about 55 and older communities, or sometimes we say 55 or better. I like that phrase. Pet restrictions, leases, sales, guest restrictions, parking, vehicle, nuisance conduct. These are all covenants that are probably in your governing documents, maybe are in your governing documents, and things that ultimately could end up with violations that you have to enforce. Anytime there's a violation, first step. So if we notice that Mr. Jones is in violation of one of these covenants, so perhaps you do have a no trucks can be parked overnight. And again, I know now trucks is no longer a good example, but put a pin in it and we'll come back to that later. But that's the example we're going to use right now. Let's say your declaration is crystal clear. No trucks, no work trucks may be parked in a driveway overnight. They have to be parked in the garage, perhaps. And Mr. Jones parks his truck in the driveway consistently. That's a violation. It's a violation of your governing documents. What do? First step, you got to tell Mr. Jones he can't be doing that. You send a notice. That can come from your management team. That can come from the board. Either way, you should include in there what the violation is, what the actual provision in the declaration controls this and what he's violating. So if that's Article 10 of your declaration, give him an idea of what the violation is. You can't just say, hey, move your truck. It needs to actually indicate, oh, Article 10 of the declaration says that no trucks can be parked overnight, and we keep seeing your truck parked overnight. Please make sure it's in the garage going forward. And you give them the description of how they cure it and a deadline to cure it. And that deadline really needs to be reasonable. If it's something like, move the truck into the garage, that's pretty easy. That's a reasonable deadline could be pretty quick. 5 days, we don't want to see the truck in the driveway anymore. That now needs to be, there's not a crystal clear answer as to what those timeframes are when we say give them a reasonable time. Again, it needs to be reasonable. So if we're talking about, we need you to pressure clean your roof or something that's a little more significant. We need you to paint your house because it's chipping and looks terrible. That's a bigger, undertaking. So that's not a 5-day notice kind of violation. That would be something 30 days, something like that. So again, reasonable. Send them a notice, give them a time to cure the violation, let them know what the violation is, give them the actual description of what again, what article, what provision in your declaration is being violated. And then that's step one. Send them the notice, give them time to cure it. If they don't cure the problem, if they don't fix this violation, now we have other tools available to us. We have some options. We're going to get into all of them here. Essentially, this is your sort of cheat sheet. You can fine, you can suspend use rights, you can suspend voting rights. Self-help might be an option. We might have to take it even further, get the lawyers involved. We may end up in mediation or arbitration, and then we may end up in litigation. And I say that, and I'm glad it is on this slide as an actual option, because we've had clients and we've had board members and CAM say to us, hey, I've sent notices, we've tried to fine, we've suspended voting rights, and the person doesn't listen, and they keep doing the things they're not supposed to do, and this violation is still outstanding. And I guess there's just nothing else we can do. So here we are. That is not the case. You can try all of these tools, or maybe some of them, whatever it is. But the answer is never just, and then there's nothing else we can do. There is always an option, or should be, depending again on your scenario, but talk to your attorneys. You may have to actually push it to litigation. Again, you have a fiduciary duty to enforce these covenants as a board member. So you need to actually pursue these violations If the owner needs to come into compliance and still hasn't done it after all of these, things you've tried, you may need to file an actual lawsuit. And I know it sounds silly, but it may take having a judge issue an order to this person saying, Article 10 says you can't park your truck in the driveway, so Mr. Jones, move the truck into the garage. If that has to come from a judge, maybe it has to come from a judge. But again, we'll get into the details in a minute. First option, the fining process. Now, we also have a lot of clients tell us, oh, we can't fine, it's too difficult. We can't find people who want to be on our fining committee. We've never fined. Or flip side, we do find people and they still don't come into compliance. Fining doesn't do too much. Well, those are all possible outcomes. We hear those comments all the time, but let's go through sort of the process and then we'll get into more detail here. Now, you may have language in your documents about the ability to fine, but you may not. If you do not, it's not the end of the world. It does not actually have to be in your declaration. Your declaration doesn't have to mention fining. The statute lets you do it, so you can do it under statutory authority anyway. If it's something you're thinking about, amending your documents down the road, it might be something you want to put in your governing documents, but it doesn't have to be there in order to move forward with this. So keep that in mind. That's very important. That's something I think that a lot of people confuse. And I've heard a lot of board members say, well, we don't have it in our documents, so we don't fine. You can fine under just the authority of the statute. But again, if you're amending your documents, maybe you want to think about putting it in there anyway. Fine amounts. And this is why sometimes fining maybe isn't the greatest tool, but we're stuck with what we're stuck with. So, all right. In the world of condos, a fine cannot exceed $100 per violation and cannot exceed $1,000 in the aggregate. So $100 per violation, but you can fine on a continuing basis. So if you have 10 days of that, truck being in that driveway, you could get up to $1,000, but that's where you're capped. So it's $1,000 in the aggregate. And then the other really bad news, and I'm sorry, but I got to break it to you, and I don't shoot the messenger here. A fine cannot become a lien against the unit. In the world of condominiums, that's very clear. Now, you're going to tell me, so, okay, we fine, and then what? If we can't foreclose it, what do we do? What good is it? It is still something you could put on a ledger. It is still something you can demand from the owner. In theory, you could pursue it in small claims court. It is still an amount they owe to you. The part that, again, is not so helpful in the world of condominiums is that it can't become a lien. So you can't include it if you want to foreclose. It doesn't acquire interest and late fees and all the same stuff that an outstanding assessment would include. But it is still something you could put on the ledger. It is still a method or still a tool you have in your toolbox. HOAs, it's a little bit different. For the most part, it's $100 per violation, $1,000 in the aggregate. But the big asterisk here is unless otherwise provided in your governing documents. So if your governing documents allow you to fine and go above those amounts, you can go above those amounts. You could end up fining someone $5,000 for a violation. You could end up fining somebody $10,000 for a violation if it's not cured and if you do it properly and all of that. Now, talk to your attorneys if you'd really want to pursue something like that. But in theory, it could be done if your governing documents, and this is HOA only, so if your declaration has language that lets you go above those limits that are in the statute, you can. Condos, you're stuck, can't do it. HOAs, check your documents. And again, maybe talk to your attorneys about amending your documents. And then you might be able to even go higher. The other part of this is if you want to, if you want the fine to become a lien, it can in the world of HOAs, but again, it depends. It has to be $1,000 or more. And so talk to your attorneys, and that authority needs to be in your governing documents as well. The fining process, similar for the two groups, for condos and HOAs, but not the exact same. Essentially, the board levies the fine first. So the board would consider, maybe some inspection reports from the manager or reports that they have that there is this violation. And at their board meeting, they would say, oh, yep, Mr. Jones is in violation. We need to send him a notice. We've sent him a notice. He hasn't cured it. So we're confirming 10 days worth of a violation at $100 per violation. We're at $1,000. Let's turn it over to our finding committee. Then it ends up with the impartial committee, and then the finding committee is going to confirm or deny. But now you would send a notice to this owner, let them know about that violation, and then let them know that they're subject to a fine if they don't cure it by that deadline. Once that deadline passes, that's when the board is going to say, okay, now we've adopted this, or we've levied the fine, and let's see if the finding committee essentially confirms it. So we have to send a written notice to that owner at least 14 days before the finding committee hearing. So it's sort of a multi-step process. It gets a little complicated. Talk to your attorneys, make sure you're doing it the right way. For an HOA, the hearing notice has to include a description of the alleged violation, the action to cure that violation, and then the hearing date, time, and information and all of that. So you can't just say, hey, you need to come to a finding committee meeting, February 1st at the clubhouse. There needs to be more information. It's a finding committee hearing to review the outstanding fine of the truck being parked in the driveway and, hasn't been moved to the garage, whatever it is, description, the alleged, method to cure, and the information on the hearing. That hearing has to be held within 90 days after getting that hearing notice or after sending out that hearing notice. The committee could do the hearing by telephone or electronic means. So you could do the committee, those finding committee meetings by, Zoom or something. And the parcel owner can also attend via telephone or Zoom, so they don't have to come in person. The committee members, and this gets a little tricky because this is, again, the biggest hurdle we hear when we're talking about finding is we can't get people to volunteer for the finding committee. And the joke is always, on the board, you don't like to be the bad guy. Well, no one really wants to be the bad guy and wants to volunteer for the finding committee because that's really, you don't get a lot of, you're not making a lot of friends with your neighbors, let's say it that way. The finding committee is made up of at least 3 members appointed by the board who are not officers, directors, employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. So it can't be anybody on the board, can't be anybody from, management, basically. So you got to find 3 other neighbors who are not on the board and who are willing to serve anyway. And again, sort of be the bad guy. That's the biggest, like I said, that's the biggest challenge we hear is that no one wants to serve on the board or on the hearing committee. So the role of the committee is limited to determining basically whether to confirm or reject the fine that the board levied. So that's why I said the board does it first, then they send it to the finding committee. The finding committee can't, negotiate. They can't come to a compromise. Hey, we have $1,000 fine, to review. We're either confirming it and then it's officially adopted and levied and all of that, or we're not, where there wasn't enough evidence or whatever they conclude. There's no sort of middle ground of, well, but Mr. Jones is really nice, or Mr. Jones is new to the community. We feel bad, $1,000, it's a lot of money. We'll just tell him it's $500. That way, everyone wins. Can't do that. Finding committee cannot do that. Their job is basically yay or nay. And if it doesn't get approved by a majority vote, the fine is not imposed. It's gone. Now, after the hearing in the world of condominiums, and I should say this too, give you a little sort of context for all of this. The last couple years, you guys may have noticed some things have changed with the statute as they do generally, but with the statutes, the trend seems to be going sort of, the legislature seems to be, I'll say, giving a little more benefit of the doubt to the owners as opposed to the associations. So a lot of what's going on in HOA world seems to be very owner friendly and less association friendly. That's the context of the last couple years. So again, part of that was some changes to the finding procedure for HOAs seems to have made it a little more difficult for HOAs to impose fines. Condominium finding process hasn't really changed, but again, we'll sort of compare and contrast in a second here. If the fine is levied by the condo board and then it's approved by the committee, The condo association has to send a notice by mail or hand delivery to that unit owner, let them know that fine was approved. And then that fine payment is due 5 days after notice of the approved fine is provided. Tight time frame. I'm not sure why they put that in the statute, but there we are.
Emily, I'm going to quickly interrupt just for a second. Folks, the chat is reserved only for the evaluation link, which we're going to place later. Please ask any of your course-related questions in the Q&A module, not in the chat. All right, so Kim and Adrian and anybody else, Q&A module only for questions. Back to you, Emily. Sorry for the interruption.
No, you're fine. Thank you. So, and now after the hearing in the HOA realm, within 7 days after the hearing, the committee has to mail or email the notice to the owner or their occupant, tenant, whoever else, the findings related to the violation. So again, a little different, the little more specific. They want findings sent as opposed to, hey, the committee approved the fine and here it is. Now, it seems like you have to give them a little bit more information. Any fines have to be obviously included in that notice, and then how that violation may be cured, which again should sort of be obvious, but may not be. And you may want to, again, make sure to comply with the new statute that you actually spell it out. If the issue is the truck in the driveway, then the fix is probably pretty simple. We need the truck out of the driveway, either in the garage overnight or out of the community. But again, it may be a little confusing if it's something like you painted the house without, ARC approval. Are you guys demanding that they repaint the house because they picked a color that wouldn't have been approved? Or is the cure, we just need you to submit the paperwork so we can review it and make sure the ARC process was followed. So we do want to make sure that the fine information is there, and then how to cure that violation if it hasn't been fixed, and the date by which the fine must be paid. That should be in there too. Also for HOAs, this is another little wrench thrown into the procedure. If that violation has been cured before the hearing, the fine cannot be imposed. That's a big change. That was something they added, I think, it's probably 2 years ago now. I have no sense of time, but it's now, that's a big difference. So that confuses people. That makes things a little bit more complicated. You need to make sure really right before your fining committee hearing that the violation still exists. So again, if that person still hasn't cut their grass, still hasn't pressure washed the roof. Now, if they pressure wash their roof, 5 minutes before that hearing starts, well, now the fine can't be imposed. So you need to make sure you're aware of that. If that violation's not cured and the fine is approved and all of that, we're moving forward with the fine, the committee has to set a date by which the fine must be paid, and it has to be 30 days after delivery of notice of the committee's findings. So again, they've made the HOA fining procedure a little bit more complicated and a little bit more owner friendly. So make sure you talk to your counsel, that your management team knows exactly how they're doing this to help you with it. Now, attorney's fees and costs cannot be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. So another little benefit to the owners, you're not going to get attorney's fees if it's before that fine is supposed to be paid. If attorneys were involved, and maybe there's some language in your documents that would want to put in some attorney's fees for some reason. But again, that gets a little complicated. Talk to your attorneys about that. All right. So HOA considerations. This is again only for HOAs. What I'm about to talk about is only under 720. It's not in condo world. It's not in 718. So again, like I said, a couple years ago, we've sort of started to see this trend that legislature is becoming very owner friendly. That tends to just sort of be the way the trend is leaning. So less so with the associations, and we're seeing a lot of frustration on behalf of the boards and the management teams now, but we have to deal with it. So here we are. Now, these sort of exceptions they've carved out seem very strange and seem kind of random, I'll be honest, from what we're hearing. But again, this is now in the statute. So notwithstanding any provision in the governing documents, the HOA may not levy a fine for either of the following two things. leaving garbage receptacles at the curb or the end of the driveway within 24 hours after designated garbage, before or after the designated garbage collection day, leaving holiday decorations or lights basically up longer than indicated in the governing documents, unless those decorations are left up longer than 1 week after the association provides notice of that violation. So the lights and the holiday decorations seem to be less of an issue. I'll be honest, we hear lots of complaints about these garbage can violations and how to handle the garbage can violations. The issue now is you can't, the statute basically says you can't fine for this as a violation anymore. And again, we have a townhome community that is in Broward County, and trash pickup is 2 times a week. So they are small, driveways with small space between. And when you have trash 2 times a week and you're allowed to leave your garbage can out the day before and the day after the trash pickup day, again, you're talking about 6 days, essentially. The garbage cans can just be out and blocking sort of driveways and in the way and not the most aesthetically pleasing view for a lot of the owners. So we have heard complaints about this, but ultimately that is what the statute now says. There may be arguments as to why you can still enforce it under your governing documents, but talk to your counsel about that. We'll touch on that briefly, but that's something to be aware of because this was a change in the last couple of years. Suspension of use rights. Again, this applies to 718 and 720. And they're essentially, they're not that different, but basically you can suspend the rights of an owner, their tenant, their guest, their invitee, all of that, to use the common areas, the common elements, the common facilities. If you have a clubhouse, if you have a gym, the best thing really, honestly, and I know it sounds silly, but is turning off the clicker or the transponder so that they can't come through the owner lane of your gate. If you have a gate community, if you're a gated community, and they can't go through the owner resident lane, and all of a sudden they have to stop and talk to the security guard every single time they come in because their clicker doesn't work the same way they would if they were a guest or a visitor or any of that. They have to be able to come into the community, let me be clear, but you can turn the clicker off. Now, same thing with, clubhouse, gym, pool access, that kind of thing. They need to be able to come into the building, get to their unit, but you can stop it so that they can't use the pool anymore. They can't, their key card doesn't work for the gym if you have those amenities. Now, different ways this can be done. If a member is more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation, you can suspend their use rights, or for failing to comply with the governing documents. So sort of 2 different ways. One relates to a delinquency, one is related to just violations. If we are talking about, again, suspending use rights, like I just said, there are certain things that you can't prohibit them from doing or from accessing. In the world of condominiums, they need to be able to park, they need to be able to come into the community, they need to be able to use an elevator. And I know that sounds silly, but we've had people ask, can we, turn off their access to the elevator if you have one of those sort of key elevator buildings. For HOAs, it's coming in through the gate. They need to be able to walk in. They need to be able to drive in. You can't, sort of keep them from bringing their car through the gate. But you can, again, limit it to just using the guest lane as opposed to the resident lane. For monetary violations, so this is when we're talking about a delinquency. The delinquency has to be over a 90-day balance, 90 days past due, has to be approved by the board. It's only a board decision, board meeting, 48-hour notice at a properly noticed board meeting. And you have to notify the owners or the occupants, invitees, whoever it is, tenants, whatever it is, once that's approved by the board. And then that suspension ends when the delinquency is paid in full. And again, it may sound sort of silly, but I used to do some collections work, and there was a foreclosure case where a gentleman would call all the time and say, my wife and teenage daughter are going to kill me if you do not turn my transponder back on and my clickers back on, because they hate stopping at the gate. They hate talking to the guard. What do I need to do? How do I pay? Can I work out a payment plan? Please help me, essentially. So it is something that gets owners' attentions. Now, for non-monetary violations, so if you're suspending use rights and it's not related to a delinquency, it's related to more of a violation, a behavioral issue, that's essentially done the same way you would do the fining committee or the fining procedure. So you have an impartial committee. It could be a grievance committee, violations committee, whatever you want to, call it. And then that's done, again, sort of the same way that the fining procedure is, in terms of it's approved by the board, then sent to the committee for, final approval, 14-day notice, all of that. And you guys can look into these details a little bit more. Similar to the fining committee in that it has to be 3 members who are not officers, directors, employees, or the spouse, parent, child, brother, sister, director of employee, blah, 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 blah. You can read through that. And ultimately, again, very similar. The hearing, that committee has a hearing, they vote. And if it's not approved by majority, then the suspension isn't imposed. If it is, the suspension is imposed. After the hearing, in the world of condominiums, you have to send the written notice of the suspension by mail or hand delivery. HOAs, it's a little different. Within 7 days from that hearing, the committee has to mail or email the written notice. And again, they have to sort of outline a little bit more in their notice that the committee approved the suspension, how that can be cured, how that violation can be cured, and how that suspension would be lifted, essentially. If the violation has been cured before the hearing, again, sort of same little caveat to be aware of in the world of fining, it comes into play here. If that violation has been cured before the hearing, you can't suspend use rights anymore. Suspension cannot be, you basically don't go forward. Okay. All right. And then same additional sort of exceptions here, only for HOAs. You can't suspend use rights for those 2 things we talked about, holiday decorations and garbage cans. Now, again, why those are carve-outs in the statute is beyond me, but here we are. All right, so that's suspending use rights. Now, suspending use rights, like I said, the biggest way you see that as a practical matter is turning off a transponder, key fob, clicker, something like that. Owners still need to be able to come in, their tenants still need to be able to come in, guests still need to be able to come in and access the community. They need to be able to park, they need to be able to use elevators, all of that good stuff, but you can keep them from basically using the gym, using the pool, using the owner lane. That's the biggest penalty that we see. Now, suspension of voting rights, similar, but a little different. So let's get into that. This is another option. The association can suspend voting rights of a unit owner or parcel owner if that owner is more than 90 days delinquent. So again, that same window of delinquency is relevant here, 90 days delinquent, paying any fee, fine, or monetary obligation due to the association. Now, it's interesting the way they've worded this, because sometimes the statute specifies that it's relates to an assessment or something like that. But in these sections, it really says fee, fine, or other monetary obligation. So again, if you did fine an owner for having an outstanding violation, that fine would still, maybe that fine is still on the ledger because they refuse to pay it and they refuse to whatever it is, and they know, maybe they took a class and they know you can't lien them for it, so they're just going to leave it on the ledger and tell you to, go fly a kite. Well, if it stays on their ledger, then they owe you a monetary obligation, and that might be a reason that you can suspend their use rights or suspend voting rights. So again, there's a little leverage there. For condominium associations, the monetary obligation due to the association has to be more than $1,000. So that's something they added maybe 4 years ago now, more than $1,000. And proof of that obligation has to be sent to the unit owner 30 days before the suspension takes effect. Now, the way that's interpreted can be a little loosey-goosey in terms of, does that mean you have to send them a notice that says, in 30 days, we will suspend you if you don't pay this amount? Or is it, well, we sent them a late notice. We sent them a delinquency notice. They already knew that they owed us money and they had 30 days to pay and they didn't. So they already got proof of that obligation already. So now we can suspend them, right? So talk to your attorneys on how you want to interpret that and how aggressive the board wants to be with that. The other part to keep in mind, if we're talking about suspending voting rights, odds are you're voting, the most important vote you guys have is probably your election. At least 90 days before the election, the association has to notify its unit owners that their voting rights may be suspended due to a non-payment of a monetary obligation. That's for condominiums. So 90 days before the election, you have to notify your owners if you're going to suspend voting rights. The suspension is done by board. It's a board vote at a properly noticed board meeting. Again, we always sort of say, if you guys need guidance in terms of how to put, how to word it on your agenda or how to do it, you can just put on your agenda an item that says, consideration of suspending voting rights for every owner who's more than 90 days delinquent and a monetary obligation owed to the association. Or if we're talking about use rights, consideration of suspension of use rights for any owner who is 90 days delinquent in the payment of any monetary obligation. You could even make it sort of a regular board agenda item if it's something that you have in your community where you do want to be suspending these rights. Put it on your agenda and discuss it regularly at board meetings. And then your manager can tell you who that applies to. You can make a motion that applies to everybody the manager, just read off the list. Seconded, approved, and then send the notice after the meeting. So you have to notify your owners, obviously, if their voting rights are suspended. Interesting thing when we're talking about voting rights here, a voting interest that's been suspended is subtracted from the total number of voting interests in the association. It's not considered for any purpose, including the percentage or number of voting interests that are necessary for quorum or to conduct an election or to approve an action. So you have to do a little math and maybe consider whether you want to suspend voting rights, because that could change up your analysis and your, what percentages you need and how many owners you need to vote or participate, things like that. So talk to your attorneys before you do that. And that suspension is going to end upon full payment. Now, there was a little complication some years ago that basically found that suspending voting rights is a little different, because voting rights are really important. We value the ability to cast our vote. So because of that, and I don't want to get down this rabbit hole too much, but there was a case that said that the association could not suspend voting rights based only on the statute because of how the language in the declaration, when the declaration was drafted, and the declaration did not have Kaufman language. Kaufman language is the language that says that the association is subject to the statute as amended from time to time. Those are sort of magic words you hear us talk about all the time. Kaufman language, again, means your declaration changes with the statute, follows the statute without having to be amended separately. If you don't have Kaufman language, then the argument is your declaration is subject to the statute as was in place at the time your declaration was drafted. So if your declaration was drafted in the year 2000, you're subject to the statute from the year 2000 to certain things. And there's another layer to this, whether the change is procedural or substantive. And the argument was this was a substantive change to the statute because voting rights, again, are considered important. And if you didn't have Kaufman language that said basically we're following the statute, and the statute didn't allow you to suspend voting rights previously, in that case, they said the association improperly suspended someone's voting rights. So it is a complicated analysis. If you're thinking about suspending voting rights, talk to your attorneys, look into it before you do it to make sure you avoid this issue. Self-help. Self-help is an interesting topic that's been sort of in the news in the last couple of years. Essentially, look at your governing documents, see what they say. Do your governing documents allow you to sort of step in and do, a repair for an owner or fix the violation that an owner may have? If it's something sort of smaller, if it's an issue with an HOA, maybe, hey, we need this owner to cut his grass. The grass has gotten too high. Do your documents actually say, and if the owner doesn't do it upon certain notice or blah, 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 again, different ways this could be worded, but if the owner doesn't do it or fails to do it, refuses to do it, the association may step in and do that, take that on and perform that maintenance obligation. Your declaration may say that, and then that's an option. But now you need to check your governing documents to see if that is something you can do. And then obviously you need to analyze if that is something the association wants to do or can realistically take on. You're not going to pressure wash someone's house. You're not going to replace their roof. You're not going to paint their house, but maybe weeding the driveway or cutting the grass. Those are things you may be able to do as a board, as the association. And then maybe you can recover for that. That's the other part of it is, well, do you have the authority to do the work? And then do you have the authority to recover the amounts you spent, the cost of doing that work? So all important considerations, but that's all going to depend on the language in your governing documents, most likely. So that's self-help. When you hear us talk about self-help, it basically means, can the association take on that thing and fix that item or perform that maintenance issue? Now, there have been some cases about this in the last couple of years. So this is something else that you want to look at. You want to talk to your attorneys. Essentially, depending on where you are in Florida now, there's some different cases that are saying, well, does the association have to try self-help versus can the association pursue legal action without having to try self-help? And again, there's a big analysis here of depending on where you're located in Florida. There was a judge who recently, concluded that, maybe it doesn't make sense to make the association have to try self-help, because do you really want to send vendors onto someone's property if that owner has told you, do not come onto my property, and if someone does, I'm going to take action. We live in in an interesting time, and there are a lot of guns in Florida. And that is what the judge even pointed out. You don't want to send someone who doesn't have permission of the owner onto their land, essentially. It just could be a recipe for disaster. Now, it's a little different for condominiums. It's a little different when we're talking about, shared space where we need to fix this leak because it's causing an issue downstairs and there's still water coming in. Those are all sort of different considerations, but all things to talk to your attorneys about to figure out the best method for fixing this outstanding violation. Now, sort of your last Hail Mary, how do we fix this? How do we get this owner to come into compliance? Is probably going to involve some sort of dispute resolution. For condominiums, what does that mean? Now, there are a couple different options here. Arbitration, pre-suit mediation. We're going to talk about pre-suit mediation in a few slides when we get to HOAs. HOAs are generally it's covered under 720. So the pre-suit mediation process we talk about usually under HOAs, but it is something that's available to condominiums now as well, because they changed the statute recently. What used to be the case is every dispute, or a lot of the disputes, would end up going to the division. There'd be a petition for arbitration, or again, possibly mediation, but keep in mind, election and recall disputes do not go through the mediation process. Those do go through the division. They have to be arbitrated by the division or filed in court. If there's an issue with, again, an election or a recall in the world of condominiums, it's going through the division or it's going through court. Every arbitration petition received by the division gets handled on an expedited basis if it has to do with elections and that sort of thing. Because again, you can understand the time sensitivity of an election. Generally, by the time, if it were a normal lawsuit, we would already be up and around to another election by the time we get anywhere. Now, the mandatory pre-suit dispute resolution procedures don't apply if we're talking about non-residential condominiums, so don't worry about those. The eligible disputes, and dispute is actually a term in the statute that is defined. Now, dispute means any disagreement between two or more parties that involves the authority of the board to require a unit owner to take action or not take action, or to alter or add to the common area or common elements. So again, that could be something with the board can't tell me I need to paint my house, or I need to stop parking my car in the driveway, or whatever it is. The failure of the condo association to properly conduct elections, give adequate notice of meetings, conduct meetings properly, allow inspections of books and records. Those are all things that could be disputes. An owner could be challenging what the board is doing. Again, an owner could file a complaint or file an arbitration petition with the division that maybe the board isn't properly noticing their meetings, not properly having their meetings, things like that. There are also disputes that aren't subject to these same procedures. So anything where title is involved, that sort of falls into a different category. If we're talking about an assessment, collection of assessments, that's treated in its own, sort of category of things. If someone owes an assessment, There is a whole statutory procedure for how you collect on assessments. It involves one notice from the community or from the board, a notice of late assessment. That's a 30-day notice. Then 2 additional statutory notices that can come from the attorney that are 45 days each to pay before you file a claim of lien, before you foreclose that claim of lien, and then you file a foreclosure action, and that directly goes to court. You don't have to worry about the division and petitions for arbitration and that sort of thing. Claims for damages to units, that may be treated separately. Now, a petition for arbitration is not going to be accepted if it involves issues that are moot, if it alleges that the association failed to enforce the documents. These are sort of other things to consider. So again, if you, the association, are considering action, obviously your attorneys are going to guide you on that. You may also be on the receiving end of one of these arbitration petitions. Sometimes we don't even know the owners have filed them until, you know, it's sort of later down into the road or down the road. The petitions have to be filed using the division approved form. It is supposed to contain proof of what their allegations are. They're supposed to have provided advance notice of the specific nature of the dispute, a demand for relief, and a reasonable opportunity to comply, and then the notice of intention to file the arbitration petition. So, you know, in our case, sometimes we receive an email that says, hey, board, you didn't do the election right, and if you don't redo the election, I'm filing a petition for arbitration. Well, would that be compliant? Does it actually notify what the problem was? Does it actually give you notice of, you know, a reasonable opportunity to come into compliance? All of these things. All of that can be a little bit of a complicated analysis. Again, talk to your attorneys and see what they think. Just based on that type of demand doesn't mean you necessarily have to reply, but then that would be enough for them maybe to file a petition and say, hey, I complied with all of the, you know, these sort of pre-arbitration requirements, but maybe they didn't. So again, talk to your attorneys. There's a filing fee. They have to send it to all of the respondents. The petition is promptly reviewed by the division. They have to confirm that it actually basically falls into their jurisdiction, that there is a dispute here, that the filing fee was paid, and that the procedural portion has been complied with, that the advance demand was in there, that it's attached, all of that. Once that's confirmed, then they assign an arbitrator to it, and then a copy of the petition is sent to all of the respondents. And basically they send an order that says, okay, here's the petition, you know, what say you, essentially, here, file, you know, tell us your answer. The arbitrator is going to conduct a hearing within 30 days after being assigned or entering into or entering into a contract, unless that petition is withdrawn. Could happen, or there could be a continuance granted for a good cause. Again, sort of getting into the nitty gritty, this is where you want your attorneys to be helping you out here. Respondents have a 20-day window to file their answer to that petition. Possible, you know, ways to answer or things that could be raised that aren't even necessarily getting into sort of the substance of it: lack of jurisdiction, insufficiency of process, failure to state a cause of action. These are all things that could be raised. And the answer is supposed to include all defenses, because ultimately the arbitrator, the way they want this done, they want it kind of streamlined. They want the arbitrator to be able to look at everything kind of in one package and make a decision based on that. So you got to put everything, you know, in for your answer, you got to put everything in there. Not a counterclaim, though. A counterclaim is a separate issue. Now, you may also end up going to mediation. Before or after you file that answer, the respondent files an answer, the parties can request to be referred to mediation by the division. And or potentially the arbitrator sends you to mediation regardless of whether or not anybody asked. That happens occasionally. So could go to mediation, might get worked out there. Most people kind of know how mediation works, and we're going to talk about that a little bit more in a minute. The mediator declares an impasse, then the arbitration proceeding is done, terminates. In that arbitration proceeding, the arbitrator can't consider any evidence related to that mediation. If the parties don't agree to continue arbitration, the arbitrator dismisses the case, and either a party can institute a suit in court, basically. So interesting sort of procedural methods here that are at play. So again, very important to have your attorneys involved. The arbitrator will enter a summary final order denying relief if no disputed issues of material fact exist, and basically there's no basis for relief. That could happen. At any time after filing the answer, the arbitrator can enter a summary final order awarding relief if, same thing, there's no disputes of material fact or there were no defenses exhibited. So basically, either there was no, no violation here, or yes, there was, and here's how so-and-so needs to fix it. Arbitration hearings, those are all set by the arbitrators. Usually they're done via Zoom or sort of a teleconference, but essentially it's handled like a mini trial. It's a hearing where you can present evidence, all of that, and the arbitrator makes their decision within 30 days. They can grant monetary damages, declaratory relief. They have a broad sort of spectrum there. Arbitration is going to be binding if the parties agree to be bound, which is interesting. Also binding on the parties if basically nobody files a complaint in court within 30 days. So it can be binding on the parties if we all sort of just let it go. If not, somebody's going to have to file a complaint for trial de novo in court within 30 days to basically challenge the arbitrator's decision. Attorney's fees, that's a big part of it. Hey, do we get our fees? We get that question all the time. We're not going to pursue this because we don't want to spend the money and we don't think we'll get our fees or whatever it is. And this is another thing that may be new to you guys. You can get attorney's fees. If you're the prevailing party, if the association basically wins in an arbitration case, they are entitled to an award of their costs and reasonable attorney's fees. That can happen even for attending the mediation, all of that. Now, it's not a guarantee and you have to be the prevailing party, but that is something that can be considered. Now for HOAs, dispute resolution is a little bit different because we don't worry about the division for the most part. We don't get into petitions for arbitration. We're just talking about, pre-suit mediation. It's similar in terms of kind of what our categories are. There are certain disputes that are going to be subject to the pre-suit mediation demand, and there are certain disputes that are not subject to the pre-suit mediation demand, and that means they go right to court. Now, FYI, I understand we actually, and Jeff, maybe you can just mention this details to everybody. Since I'm saying the word mediation so much right now, we actually have a new class just on mediation, right?
That is correct. We will soon be scheduling, and maybe Michael will be interested in doing this together. We have a brand new mediation class that covers just that, everything you need to know before heading into it, what must be done before heading into it, and whether you need to head into it or not after determining whether you need it or not. And then on top of that, those of you in the Palm Beach area, Jeff Rumbaum will be teaching it at the Palm Beach Expo in February and Alan in the Orlando Expo in April. Back to you.
Okay, good. So like I said, pre-suit mediation ends up becoming very important, and you may end up going down this road even in condo world as well. But the pre-suit mediation demand is, we say it so much, but the words actually do have meaning. It is a mediation demand that has to be sent pre-suit. So before you can file a lawsuit, you have to demand, let's try mediation first. Now, again, there's a procedure, there's a whole form, there's all of this, and we don't need to get into the nitty-gritty of that. It'll be here on slides. You guys can talk to your attorneys, but the gist is if you have an owner who is not coming into compliance, who is not doing all the things they're supposed to do, who's in violation for whatever reason, the truck, the house that's, not being properly maintained, or all of these other things that could be potentially, outstanding. You could try finding them. You could try suspending their use rights. You can try suspending their voting rights. You can try all of these things, and you still may have an owner who basically snubs their nose at you and says, I'm still not doing what you want me to do because I don't want to, and I live here and I want to do what I want to do because it's my property or whatever it is. Well, your governing documents, again, the board is responsible to enforce them. If your governing documents say that those certain things shouldn't be done or should be done, and this is a violation, you need to be enforcing that as a board, as an association, or you're going to run into a problem. So pre-suit mediation was the solution many years ago where they thought, let's just get owners and the association kind of in the same room with the mediator, see if we can work it out, see if the mediator will tell, hey, Mr. Jones, you cannot park your truck here overnight. I've reviewed your documents. The association's right. This is obviously done when the association's not in the same room, but the representative, the board's in another room. But maybe the mediator will say to Mr. Jones, hey, you have a terrible case here. And if they go to court, you're going to have to pay attorney's fees and all this stuff. And maybe it gets worked out at mediation. And that would be great. Saves everybody money. You do have to pay for mediation. Obviously, you're paying for attorney's fees, but it's still cheaper than filing a lawsuit, most likely. So that was the thinking. Again, it applies to all these types of different disputes. Like I said, there's a whole procedure when we send the letter. I don't want to get into all this, but you guys can read it. And ultimately, you may end up in litigation if it doesn't get worked out through mediation. All right. So what does that mean? You are entitled to recover attorney's fees when you actually have to file a lawsuit for one of these actions. And maybe it's for injunctive relief. You should be entitled as the prevailing party. If you're filing something, filing an action under your declaration, essentially, it's a breach of contract. Your owner's not following the provisions in your declaration. You should be entitled to your attorney's fees if you're the prevailing party. There are affirmative defenses that I need you guys to be aware of. This is why I said in the very, very beginning, you have a duty to uniformly and timely enforce these governing documents and enforce these, pursue these violations, because if you don't, you're going to run into a problem. And this is your list of problems you might run into. If we file a lawsuit because, Mr. Jones keeps parking the truck in the driveway, what could Mr. Jones argue? Well, there may be arguments that a judge actually finds are successful and causes the association to lose the case, even though there is a violation there. And that could be selective enforcement. Something where you have a similar violation that the board isn't enforcing or didn't enforce, and it has to be a similar thing. You can't say, well, the board doesn't, enforce our ARC guidelines, so I'm allowed to park my truck in the driveway. Those things have nothing to do with one another. Saying they don't enforce the ARC guidelines as to, paint color, so I should be able to put whatever pavers down in my driveway that I want. That might be something that's a little more connected and has a stronger argument in front of a judge. So it needs to be something related. If the association's not properly enforcing their governing documents, selective enforcement is something that's probably going to come up, where they can say, hey, but Mr. Johnson gets to do XYZ, so I should get to do XYZ. That's going to be a successful argument in front of a judge. Equitable estoppel, any of these estoppel arguments really have to do with kind of waiver. If you have an estoppel request, and this may come, to be a management issue, if they ask you what violations are outstanding for that unit or for that parcel, and you don't indicate what they are, and now a new owner moves in and you send them a letter saying, oh, hey, you have, an unapproved, whatever it is, mailbox. Well, what do you mean? I just bought the property and the estoppel says there are no violations. So I didn't change the mailbox. The mailbox is the same mailbox that was there when I purchased. Do you need to see a picture of my, the listing? Now you're estopped from pursuing that violation because you needed to mention it in the estoppel. So you may have waived the ability to enforce certain things. Latches, that really has to do with time, waiver, the same thing. If you've just waited too long to enforce some of these violations, if the association just hasn't taken action when they knew or should have known that the violation was outstanding, it's going to run into a problem when it tries to, file a lawsuit about it. An owner may say, hey, wait a minute, maybe the issue was an unapproved mailbox. Well, I've actually had that mailbox in my, in the lawn for 10 years. What do you mean it's unapproved? I haven't changed my mailbox. It's the same mailbox that's been there for 10 years. You can't pursue me now just because it's a manatee and that's not approved. Whatever it may be. But again, that's why you need to make sure you're enforcing these violations in a timely manner and in a uniformly manner. All of these are potential arguments. Waiver, like we said, if the board isn't taking the action and is not enforcing, these could be raised as affirmative defenses, and now you can't enforce. Now, I'll sort of end with, ultimately, if there are violations that you haven't properly enforced in the past, talk to your attorneys about maybe republishing. You may have to republish the the provision, the restriction in your governing documents, and that may involve grandfathering in some current violations, just so you can draw a new line in the sand and you'd have a new time frame where you can say, as of, whatever it is, March 1st, we're enforcing that you can't have manatee mailboxes, whatever it is. But everyone who has a manatee mailbox now, even if you didn't get approval, but you may have had it for so many years and we didn't properly enforce and all of that, we're going to let you keep your manatee mailbox as long as you register it with us and you're grandfathered in. Now, when we say grandfathered in for republication purposes, it does mean that actual violation. It doesn't mean that Mr. Jones has free reign to do whatever he wants and put in any kind of mailbox in the future. It means just that manatee mailbox is grandfathered in. When we talk about trucks or when we talk about pets, because we get oftentimes we grandfather in pets for condos, it means that Fluffy is grandfathered in, and when Fluffy passes away, because they don't all live forever, then too bad, Mr. Jones doesn't get to get a Fluffy 2.0. So that's important. That's another option for you guys. Talk to your attorneys about republication when we want to try to sort of clean things up and get these violations cured going forward.
Emily, what if it's a shark mailbox? Does the same thing apply?
I've never seen a shark mailbox, actually. The manatee ones I see all the time.
Maybe in San Jose or something. I don't know.
But people asked sort of to clarify the fining procedure. So Florida statutes do talk about allowing condominiums to fine. That is allowed. The issue now, someone said, what if we don't have a fining committee? That's going to be your biggest hurdle. You can't fine if you don't have a fining committee. So you need the fining committee to do anything. That's for HOAs or condos. Somebody asked about e-bike policies and enforcement. I know I hear that's sort of a hot new topic. Ultimately, talk to your council. Maybe you want to adopt some new rules, some policies about that type of thing. If people are speeding through the community, that could be something that could be treated as a violation. With any of these violations, with any of this, behavior that may be sort of a problem in your community, keep in mind when you're going to want to send these violation notices, and down the road, if you end up in mediation or if you end up filing a lawsuit, you're going to need evidence. You're going to need documents. So you want to make sure, and this is where your management team really comes in to play here, make sure you're documenting these complaints. If you have a neighbor who says, my next door neighbor does this every day and doesn't clean up after their dog, or again, whatever the violation is, make sure you're tracking those emails that you're getting, those complaints. If the person sends you a video, sends you photos, you want to have documents and evidence of whatever the alleged violation is, so that down the road you can prove it and you can say it's not just going to be a he said, she said. You have the evidence, whether that's for any step of the way, the fining, again, if you end up in mediation, you need to be able to prove these things. So make sure you are documenting it. You're keeping the complaints. If your owners are complaining and then they say to you, maybe they say at a board meeting, well, I don't want to get involved. So I don't want to send you a note. I don't want to send you an email about it. I'm not going to put it in writing. I don't want to get involved. Then you're going to have a proof problem. You need your owners to actually help you as a board, help your management team. Your management team doesn't, live there every day. They only know what they're being told. They only know what they can see. They're not there 24/7, watching everybody all the time. Your owners need to help you out. So if they see things, they need to tell you, they need to put it in writing, they need to send something to management, again, photos, video, whatever they happen to see. If you can't document these things, that's going to be your other hurdle. You can't enforce if you don't have proof of what the violations are. Michael, you guys have, and I know I've seen it, you guys have a very good sort of program, right, that you use for tracking these violations?
Yep, it's a digital process that we use. Yeah, that makes sure to get all the evidence necessary and to communicate it. Absolutely. Let's see, I see a question here. Can the board find effective the date of the board of directors meeting date, or should the effective date begin when the hearing committee confirms the fine?
It's so, and this is, again, it gets a little tricky, kind of the logistics of how to do it. And I would talk to your council about how they recommend it, because we don't all agree on the best procedure. But generally, the way, to me, the board should approve it. The board should be approving the violation and the fine for the violation, that either preemptively, we're going to send this notice, and if it's not cured after these 10 days, we approve the fine of $1,000. Or they've already had the 10 days and we already have the evidence of it and we're approving the $1,000, hypothetically. But either way, the board has to be approving that $1,000 fine and then sending it to the fining committee. So the violation's already, at that point, already happened, or they've already warned that it's going to occur if this is not cured. And then it's sent to the fining committee sort of after the fact, after the board has already approved it. And then at that point, you're making sure they got a 14-day notice. There may be a little bit of a delay if the board kind of makes that decision and says, going forward, there's the next 10 days, we're going to treat it as a violation. Then you need to make sure, again, your hearing date is down the road a bit. But talk to your attorneys and the best way to handle it. Because again, I know we all kind of have a difference of opinions on the best way to handle it. It does get tricky. Fining is, again, we hear a lot of complaints that it's maybe not the best tool, but it is a tool available to you. So I got to tell you about it.
So here's a tricky, speaking of tricky, the question is, what if it is a repeated intentional violation? The owner has done the same violation time after time, curing the day before fining meeting, and then repeating it the very next day.
Yes, this is what that's the biggest complaint is, well, we told them that they weren't allowed to do X, so they stopped doing X for a minute, and then they started again. Ultimately, what you're probably going to end up doing, now keep in mind, the fining procedure is not meant to be, a profit source for the association. You're doing it to get them to come into compliance. That's really the purpose of the fine. If they're not coming into compliance, and again, there's talk to your attorneys in terms of sort of fining for a certain period, and maybe after, if they violate again 6 months later, we're treating it as a new fine, but talk to your attorneys and see, get guidance on that, because again, difference of opinions on that point. But ultimately, the bottom line is, if this person still keeps doing whatever the violation is, you probably need to take other steps. We probably need to send a pre-suit mediation demand. You need to get your attorneys involved. You need to actually pursue legal action against them. I know that's not the answer anyone wants to hear. I know you don't want to have to end up in a lawsuit about somebody who's, parking their truck in the driveway, but that may be the only way to get them to come into compliance. Yeah.
I'll tell you, I remember when I was on site, we had somebody, large scale community. We had a well-to-do person who lived in Manhattan most of her life, used to paying astronomical numbers for parking. Okay. So she would come to our theater shows every Saturday, park wherever the heck she wanted, got a ticket from our security staff. And when we asked her, and she was a very nice person, she wasn't rude or anything, but when confronted at one of the meetings, she was like, "Why do you keep doing it?" She's like, "These tickets are nothing. I used to pay all this money every day to park in Manhattan. I'm going to park wherever I want." It was quite funny. I mean, annoying, but funny.
Oh, I've heard owners say that. Go ahead, find me. I don't care.
Yeah.
And either the problem is they know that, if they're in the world of a condo, they're not getting a lien for it. So they just assume it'll kind of go away eventually.
Yeah.
Or they don't care. Or, okay, send me $1,000 fine and I'll pay you, but I'm still parking my car on the street.
Yeah, because I used to pay $3,000 a month. $1,000's nothing.
Yeah. Still going to do it. Now, and I saw somebody comment about, what about towing? Towing is another option. It's not a general covenant enforcement tool, but it is something that may be an option for you. Talk to your attorneys about making sure you do it properly. But towing is another enforcement tool in your tool belt. The fining again gets a little tricky, and I know that's the one that everybody always wants to ask about. I also see comments about the trucks and the trash cans and that whole thing with the changes to the statute. Talk to your attorneys, because there is an argument there. If you had Kaufman language, don't have Kaufman language. If you don't have Kaufman language, perhaps you still can enforce your truck restrictions. Again, the statute changed that if you're in an HOA, work trucks are supposed to be allowed to be parked in driveways now, even if your documents said no. But again, there's a whole Kaufman language analysis that depends on what's in your documents, what the statute says, when your documents were written. Talk to your attorneys. That's why this is all general education, guys, not legal advice. Because it gets more complicated than it sounds like it should, basically. Someone said, is an owner liable for their renter? Yeah. When if you're the owner, you're responsible for the behavior of your tenant. So if the tenant is doing things they're not supposed to be doing, in my opinion, the owner needs to get a letter and the tenant needs to get a letter. Hey, stop, again, parking on the grass or throwing those late night parties and leaving trash, in the street. whatever the tenant's doing that they shouldn't be doing, the owner's ultimately going to be responsible for it. And the board, again, depending on what the documents say, the board may have the authority to then not renew that lease. If they had lease approval authority, maybe we're going to say, hey, your tenant needs to get out at the end of the lease term. We're not going to approve a renewal because they've documented that they don't follow our rules, which again, that's why we want everything documented. Or if it's so bad, if these tenants are so bad and they've only been there a month and they still have, 11 more months on their lease, there might be a world where the association actually has to pursue the owner to say to owner, you got to get rid of these tenants ASAP. This is how bad they are. So lots of different ways. A lot of it is really going to be very fact specific. So this is why we're saying this is really a general conversation and a general course for you guys to just kind of give you some ideas, but we can't get into everybody's hypotheticals.
Yes. So we'll wrap it up here. So I want to thank all of you for joining us today. A super big thank you to Emily for sharing such valuable insight. Jeff, I think you want to have leave some few reminders before we wrap up here.
Well, you guys, you can give your parting words, and I'm going to remain on after you both leave, and I'll help everybody out. Anybody having technical issues, and get the I'll share my screenshot of the evaluation and everything.
All right. Well, thank you guys. And I don't know. I'm sure we'll be doing another one of these soon, and I will see everybody soon. All right.
Have a great afternoon, everyone.
Thanks, Michael.